Real evidence, real drama, real verdicts. Welcome to Judge Reports, where the courtroom secrets come to light.
Good afternoon. May it please this honorable court, Dion Webster Cox appearing on behalf of Mr. Harris. How are you, Your Honor?
We will see.
We're good. We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh, I've got a substitution right here.
Signed off on?
It is.
All right, then I don't need to address. The public defender's motion to withdraw. I'll consider that withdrawn given the substitution. I do have an appearance and I will sign off on the substitution.
Thank you.
Thank you. All right. What are we doing today?
So, Your Honor, we were going to, there's several options that my client.
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
Okay.
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting what at least as I'm to understand is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments as my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before. Absolutely. I know it is not coming from you, but you also know how I am. I do. And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license, let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union. He has never had a license. In point of fact, when they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license ever. There is also then, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, the friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. The question was asked along the lines between October of 2023 and the point in time of the May 15th hearing. Was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. And being involved into the accident, that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there. And I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which, for the way we handle things in this court, would have placed him in a whole different category. We would have tried to find a way. Let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from our accident.
You were at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID. I have the date. That's the date you did it. December 28th, 2023. You did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do, you cannot have both. You either have an ID or you have a license, one of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license.
And now that's real. That's a real injury.
I have no comment.
Okay. So what we're looking for, because there are some options here. My client has indicated to me and would like me to indicate to the court that he is in the process of procuring his license. Oh, hopefully that privilege will be available to him, but he does have, as you stated earlier, and I have the receipts. He did pay the reinstatement fee. Those fees are paid. Anything that was out in the previous court, those fees have been paid, and I've been presented with those receipts. In addition, on tomorrow, he's got his permit test coming up, and then after that, because he's an adult, he's working on it so that he can take advantage of the offers that are available, because as you say, this court does want to help. Absolutely. And with that, because my client was in an accident, and I haven't seen the medical records, but because of some of the things it could be, I don't know. But sometimes our memories get a little foggy. Now, am I going back to 1999? No, I'm not. But I'm just saying that I'm saying from this day forward, he is working diligently to take the steps necessary to get his driver's license so he can take advantage of the generous offer. Thank you.
Yes, ma'am.
Yes.
Yes, Mr.
I hate to say this, Your Honor, one additional thing. I think Fletcher Cox and I need to approach the bench. It may involve Mr. Allen.
Who's Mr.
I
Allen?
know, because I know what it is.
Okay, thank you.
Well, who's Mr. Allen?
That's my bailiff.
Oh,
I will give out whatever date I can.
okay.
Counsel, you probably didn't know this, and I wasn't sure where the prosecutor was going to bring. He's got a warrant.
No, I did not know.
Yes, he has a warrant for his arrest. A bench warrant out of
Allen Park.
Allen Park. Mr. Allen.
24th District Court.
And it's still valid. I was hoping maybe that somebody was going to try and take care of it, because I'm sure if you had known, they would have been done. So much so that part of my delay in getting out of here was to make sure that it was valid. I had my staff run him right before I came out, so that if it hadn't gotten taken care of and in, then fine, we were okay and I didn't need to deal with it.
Right.
But it's still there.
Okay.
So will July 17th work as a new date for you to come back? Because as I understand it, he is right now not licensed. So if he goes in on Thursday, gets his permit, he's got to drive for at least 30 days. Apparently he knows how to do that part. Sorry, that was, I'm sorry, I didn't need to say that, but he knows how to do that part, but then he's got to go back, take the test.
Right.
And then he can do that. He may be able to accomplish it in that time, that 45-day period. If not, I mean, counsel, I just want him to have a license.
We all want the same thing. One moment. So the 17th, it may not be me, it'll be another attorney from my office who can.
Well, I don't want that.
Trial.
I don't want that.
You want me?
Yeah,
Okay.
I know. You'll never hear me say that. But I don't want to go through this whole, you understand it.
Right. No, I get it. So I started trial on the 15th and
What's my date after the 17th?
August 7th.
What about August 7th? We can just put it out and then he can do what he's going to do or not do what he's going to do, but he should be able to.
August 7th at 1 o'clock, or would it be at 9 a.m.?
I will set it at 9. We will send an invite now that we have your appearance. So you'll get a direct invite from us as to what time block he's.
Okay. And then I just need one moment to talk to my client. You want to
Yes.
tell me something? Okay. August 7th at 9 a.m.
At 9 a.m. I'm going to take him into custody on the warrant. The only question that I have, and the way I look at the warrant, the bond looks like $500.
Okay.
Two things. First, I don't know whether or not they'll come get him.
Right.
If they don't come and get him, we'll release him. We're not going to hold him. If they are coming to get him and he's going to be held. The only question I would have for you, counsel, is do you want me to set a nominal bond on this so that he gets credit, or do nothing and not worry about it? I'll leave that up to you.
Okay, that will be, but absolutely, I want him to be able to get full credit for anything that is necessary.
So let's do it this way. If he's not, so I'm going to take him in. If for whatever reason he's not released tomorrow, call my office, and with the agreement, I will set a nominal bond
Okay,
on it rather than do it right now. So he has to deal with two things. So that you're also clear. Part of the reason I'm also doing this is because I think he was warned and released, didn't take care of it. And secondly, this has been out there for 9 years.
well, I did not know about it, Your Honor. Okay,
Counsel, there is not a doubt in my mind that that's true. Yeah, no, you did not. I'd go to the bank on that one in a minute because I know you would have taken care of it.
yes,
All right.
it's going to be taken care of today. His
Okay.
wife is here, and
Okay.
it will be taken care of. So I will absolutely call your office tomorrow to see call the court to see the status of it